It's 12:05 on Tuesday, March the 19th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns. Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, we have any personal orders before we begin? Representative Towns. We're glad to see you. Anyone else? We'll go to Sergeant of Arms, Mr. Tyler Muniz, for our weekly words of wisdom.
Good morning, everyone. Chairman, I might be out of order, but I would love to introduce my family to the committee. My wife and daughter are here. If y'all wouldn't mind standing up so we can give y'all a round of applause. Now, with that said, these words of wisdom come to you by a Tennessean with two names that my daughter helped me pick out. Hannah Montana, Miley Cyrus. Accept reality and have a backup plan, but always follow your dreams no matter what. Y'all have a great Ag Day.
All right, anyone else? All right, we have two calendars today that we're going to be working off of. The first calendar will be our special calendar. There are 4 bills on there. So we will dive right in. Item number 1, House Bill 1875 by Representative Crawford. You are recognized, and he is, there he is.
Good afternoon, Chairman and Committee. I have today, I know you're all going to enjoy voting for. I can go through the simple version, which will take just a couple of minutes, or I can go through the long version. We can be here all day. Basically, what this bill is doing is it is adding dog fighting, animal fighting into the RICO statute. Anytime that there's dog fighting going on, it's been proven that there is people involved in organized crime, sexual traffickers, drug dealers, just all these different things that go along with that. And this will allow law enforcement and our judges to be able to proceed in having better cases against them. So that's the short version.
Any questions for our sponsor? Chairman Halsey.
It's a Class A misdemeanor now to fight chickens. Under current law. If you're guilty of RICO, that's a Class B felony.
That is correct.
That fighting people doesn't get a Class B felony. It seems excessive on that side to me. How do you respond to that?
Well, humans should know a little better. And that's the only thing I could say. Animals don't have the ability to really deal with that in a mental capacity. Yes, they could run, but when people take them and put them into a ring to where they can't get out and they have to fight to the death, they really don't have a say. So I'm not saying that human life is any less than animal rights, but they go hand in hand.
I'm not defending chicken fighting it by any means.
Are you sure?
I'm positive.
There's a lot of bad people that does chicken fighting.
I'm positive. I'm just we've seemed to be in a habit the last couple of years of doing away with all misdemeanors and going to felonies, and some of that trend troubles me a little bit. If you got 11 months and 29 days under a sentence on a Class A, that's a year in jail. If judges would do that, just seems excessive. Is all I'm saying.
Mr. Chairman, the only thing I would respond to that is everything that's in this bill is already in place. The only thing we're doing is adding in the RICO statute, the word animal fighting.
Representative Johnson.
Thank you, Mr. Chairman. So it's my understanding that with these fights, a lot of times we have drug involvement and sale of drugs. So what you're not talking about the dog fighting or the cockfighting specifically, you're talking about all of the illegal activity, gambling, and the drugs when that is also involved as well. Because it's my understanding there could be cartels involved with this activity. And so that's really what you're hitting, not just the animal fighting, correct?
That is correct. We're adding animal fighting into the RICO statute. And basically what the RICO statute deals with is those sex trafficking, drug problems, human trafficking, all those type things that go along with it, drug dealing.
Right. Well, thank you. I appreciate that because I know that most of the time that's what the bigger part of this animal fighting is, all of those serious crimes that surround it. And so this is going to get at that, correct?
We're hoping so. Yes, ma'am.
Thank you.
Any other questions for the sponsor on the bill? Seeing none. We're now voting to send House Bill 1875 on the full criminal. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. The bill moves forward. If which be recorded as no, please see the clerk.
Thank you, Mr. Chairman. Thank you, committee. I've got you set up, ready to go.
All right, buddy. Thank you. You're next. Yeah? Yeah. What? Get that out of your mouth.
Item number 2, House Bill 2540 by Representative Terry is off notice. Item number 3, House Bill 2068 by Representative Jernigan. You are recognized.
I'm gonna have Chairman Crawford carry my bill for me. I think we have a lot of the same talking points. So I'm gonna get over here and turn around. Thank you. All right. All right. Members, this is similar to what Senator Crawford was talking about. And it has to do with cockfighting, which is a cruel and inexcusable criminal industry here in Tennessee. Of putting two of what I would say God's creatures in a pit to fight to the death for the purpose of profit, gambling, and entertainment. Law enforcement can attest that cockfighting is closely associated, we talked about earlier, with other criminal activities such as drug trafficking, gang activity, and illegal weapon sales. This bill does two things. It would move cockfighting from a Class A misdemeanor to a Class E felony. Class E felony is the lesser of the felonies, and you're still eligible for probation under a Class E. The second thing it does, it requires a fine not to be less than $1,000 and no more than $2,500 for those with the offense of being a spectator at a cockfight. Federal law enforcement agencies have called Tennessee, quote, the heart of the cockfighting corridor. And members and chairman, I just believe it's time to raise the penalty to match the egregiousness of the act of cockfighting. And Chairman, I'm happy to answer any questions that may come my way.
All right, thank you. Any questions for the sponsor? Representative Johnson.
I guess I'll ask you the same question. Can you talk about like the environment? What other kind of crimes are committed in a space like this?
So, and to have the deja vu of the same thing, and I did mention the drug trafficking and the gang activity, illegal weapon sales as well. But and the reason, cockfighting is already a felony. I mean, it's as far as the federal, not a felony, but it's against federal law. And the feds simply don't have the resources to come in. It has to be really bigger, like what Crawford was talking about, racketeering, for them to get their attention. I think when only 8 other states in the union doesn't require it to be a felony, and when our surrounding states do, we become the hot spot for it, and they come in here. But yeah, it's associated with all that, and what we're trying to do is have this penalty to be up there to where it's discouraged, and I think that's where we are on that.
Okay, that's interesting. I didn't realize that all states surrounding us had done this so that it, or many of them.
Yes,
So it
absolutely.
leads folks to Tennessee as we are central to so many states.
Correct.
Thank you.
Chairman Olsey.
Thank you, Mr. Chairman, and thank you, sir, for being here. I just wanted to point out a couple of things.
Sure.
I'm going to get beat up over this just for arguing the other side of it.
I understand.
But based on what you just said, and you're exactly correct, you get an E felony and have it reduced to nothing. A Class A misdemeanor, you can serve 11 months and 29 days in jail, which I think is a really good sentence, a year in jail. From what I understand, there hadn't been an arrest on cockfighting in the last 5 years. Do you know if that's true?
I don't know if that's true, and it's similar to what I was explaining to Representative Johnson, is that there hasn't been a lot of, as far as the feds aren't involved because it's not big enough. I don't know why it's been, I don't know why, we know it's happening. I can't tell you why a local sheriff or local law enforcement or that want to bust up a ring. I can't explain that to you, why that, you and I know it's happening, but it's not, it turned the other way. And so I don't know if raising this up will scare folks into not doing it, but it's an egregious crime to have this type of fighting. And I would just say that we need a penalty that matches it. And it would be my hope that we would do that to discourage others, especially from other states, to come here and allow cockfighting.
Leader Lambert.
Well, I just wanted to
Leader.
state publicly, I mean, I was in favor of the other bill. I thought the RICO statute, combining these horrible offenses with other offenses and increasing the penalty was a good way to go. I have voted against this bill probably every year down here. It is already illegal. There are plenty of punishments out there. I haven't seen any of these cases in years, as the chairman said. I think the solution we have out there is working well. It is absolutely illegal. And quite frankly, the A misdemeanor penalty is more than what you get on the E felony penalty. Because if you get 2 years at 30%, you do, 210 to 220 in jail, and then you're out on determinate release. I mean, I think the math on that's more like 216, but it's some range there between 210 and 220, depending upon your credit and everything else. On a misdemeanor sentence, you're going to do at least, under the current law, 9 months. And so it winds up being that you serve more on the A misdemeanor than the E felony. I think it's a good, strong deterrent out there. And it is, I think ridiculous to fight chickens. I think it's a stupid thing for people to do. It's already illegal and you shouldn't be doing it. When you combine that with other serious crimes as well, then the last bill, I think, kind of gets to what you're aiming at here. But I respect the fact that you and the good senator bring this about every other year. And, I just, to be consistent, that's why I was for the other one that we just had, because it came at this from a different direction. And why I have been and will be today, I know on this one. Thank you, sir.
That's so. A Class C felony does carry 1 to 6 years in prison and a fine up to $3,000. I think that, like I said, you are eligible, for probation, but this gives a judge an option depending on a case-by-case basis on what comes for them.
Yes, sir. And I do just want to be clear. I mean, so what I'm talking about is most of these folks, I have not seen a lot of these folks that fall into the multiple or persistent or career offender category.
Mhm.
So on an E felony, to get up to that 6 year, you'd have to have multiple prior felonies beforehand. Now, you may have somebody out there that fits that criteria, but most of these folks fall in that kind of, just a range 1 offender, which is 1 to 2 years at 30%. So what I'm talking about is those range 1 offenders. Absolutely could be beyond that, but just you very rarely see career offenders in court. It happens. I've seen several over the years, but the 1 to 6 absolutely is the range, but that's not what you're going to see on most of these individuals. 99.9% of them, so to speak, but it is possible.
So it sounds like to me that you're saying that the misdemeanor is tougher than the felony, so we should do the felony. I'm just doing a little reverse there. Okay.
Representative Gillespie.
Thank you, Chairman and sponsor. Thank you. Just taking this in a different direction a little bit here. The part about the spectator, the punishment for the spectator, what is that now? Or is there any punishment now for a spectator, a fine?
There is, gosh, I don't know if I,
And
there is if I get the current law in here, there is a penalty right now for, and what we didn't want to do is have that Class A felony for a spectator. We wanted to limit it to the 1,000 to 2,500. So we're actually bringing that back for the spectator, because if we do this one here, it'd be a lot more than what currently is. And I'm sorry, I don't have that in front of me.
thank you. Do you mind? I've got a follow-up question, but if that is the case, or can we go to a session and ask legal that question?
We'll go out of session, hear from legal services.
Michelle Fogarty, Office of Legal Services. That is currently just a Class A misdemeanor.
Right.
This bill imposes a mandatory minimum fine of $1,000, and it would still be a Class A misdemeanor, but also with a mandatory minimum $1,000 fine.
So right now you're saying a spectator would not be fined?
Right now, it's a Class A misdemeanor, and the court would have the discretion to impose a sentence and a fine, or
To the
What?
spectators?
Yes.
Not the actual operators?
this is just a violation of subdivision A4, which is being a spectator.
Okay. Thank you.
Any other questions for legal while we're out of session? See none? Go back into session. Representative Gillespie.
Thank you so much, Mr. Chairman. So my understanding is that some people have issues with raising the actual felony level, but I'm the first person that's mentioned, and I'm just trying to get a debate here about just the spectator portion. If there was an amendment added that just kept the spectator in, but kept the other operator at the current misdemeanor level, would that be something? Would that still get your, or?
I'm sorry, could you repeat that again?
Thank you. So what I'm asking is, if we kept the operating offense at a Class A misdemeanor, but continued with what you're trying to do is increasing the fine for the spectator, would that still get what you're trying to do accomplished?
I would think that the senator that I'm carrying this for would, but you know what? Okay, I would, if you wanted to do, what, you said increase the fine? Is that what you want to?
I mean, obviously, I'm not having a conversation on behalf of the entire committee here. This
Sure,
is just me trying to help, because I'm hearing that there haven't been a lot of cases prosecuted, and that's why there's not an influx of, the people serving time for the A misdemeanor. And it seems like if we're asking for a deterrent, maybe a bigger deterrent might be to penalize the spectators and try to get their attention instead of increasing the actual prison time for the actual offense. Just throwing it out there.
Sure, I'm at the will of committee.
Well, the only issue that we have is we don't do any kind of committee amendments. Now, you could roll it to next week if you were going to entertain an amendment or not, or whatever you want to do, but there is an option for that.
Sure, I would be happy to roll to next week.
Representative Towns, you got?
Mr. Chairman, I'm gonna make a motion that we do roll it if he's happy with it, and so we can get an amendment that will be, workable with him, and they could get together and figure it out. So we can still try to do something that he's trying to accomplish. So I'm making a motion we roll it, committee roll.
Okay. Without objection, we'll roll House Bill 2068 to next week's regular calendar.
Thank you.
Thank you, sir.
I wasn't ready. All right, that brings us to item number 4, which is House Bill 2691. You having a motion and a second? Chairman, you recognize.
Thank you, Mr. Chairman. The bill does 3 things. It requires probable cause that a criminal offense has occurred for the state veterinarian to enter or representative thereof for private property. It also requires the animal welfare groups to notify law enforcement prior to entering private property and prior to making arrest or seizing property on private property.
Okay, you've heard an explanation of the bill. Questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. I guess my concern here, this sounds a lot like a few years ago, we had the Ag Gag bill, which completely changed how you can report animal cruelty. And I'm feeling that this bill appears to do some of the same things, that it's going to make it hard for someone to actually prove that something's happening. If you have to notify first, then whatever is happening can be stopped when they know that someone is coming on the property. Can you be a little more specific about how this would work?
Yes, absolutely. The first portion that I was talking about deals with the veterinarian or the Department of Agriculture, those representatives having probable cause. Speaking with them, this is something that they already do in practice, but there's nothing in it that expressly states this statutorily. And so that's what we're doing. The other parts deal with a section of code where random citizens that can call themselves a group or an organization could enter on private property without the property owner's consent. And so what we're stating here is that they just have to notify law enforcement that they're entering 362 Jones Street to go in and do a check, just to make sure. It's nothing that we're trying to do to create an issue, to prohibit someone, just to make sure that law enforcement are aware that these individuals or individual is entering onto private property that belongs to another person to do this.
Okay, so typically if a veterinarian comes when you call, so if a veterinarian has been called to the property for some particular reason and they see something, Does this prevent them in any way in either stopping what they see, reporting what they see, anything like that?
No, it doesn't stop anything. It just states that they have to have that reason. A lot of times if a veterinarian is called in cases of animal cruelty, there's already an investigation that's underway and the state veterinarian would be considered the expert witness if they're having to grade or judge the condition of these animals. That's when they would come in that case if there's an investigation. But what this bill does and what they do in practice already says that they would have to have that probable cause or that search warrant to actively enter that property at that time.
Okay, I guess I'm still really concerned about how it might limit the ability folks to prove what is happening in some of these situations. So, but thanks for the information.
Representative Towns.
Sure, thank you. As well, a little bit of clarity. This still would require a search warrant. I thought you're saying they can go on the property even without a search warrant and figure out what's going on. So it's going to require a search warrant.
I'm sorry. They've got to have probable cause, and this section that we're doing does not limit the ability to enter pursuant to search warrant. This is just saying that they have to have probable cause to enter if they go in without a search warrant.
Right, which is my point. So you don't have to have a search warrant. A probable cause is what we must have.
Correct.
Okay. Now, it may take legal to address this. So if the property has a no trespassing sign, legal, what does no trespassing mean for the person that puts that up on their property?
Oh, I was waiting
If
on
you
you to
don't
go
mind,
to
I'm
legal.
sorry.
All right, let's go out of session.
I'm sorry.
Michelle Fogarty, Legal Services. Even if a person has a no trespassing sign, if someone has a search warrant, they can still enter the property under the search warrant. Is that your question?
So if there's only probable cause, if there's probable cause and there is no search warrant, will they be able to enter then?
There may be exigent circumstances that would allow them to enter.
Well, if there was a fire or you saw something, somebody was, I don't know, maybe you can see from not too far that maybe somebody falling down and they were needing help. I guess there may be exceptions for stuff like that, but on a normal basis, you're saying they still would be able to enter with a no trespassing sign.
If there's probable cause to believe that a crime's being committed, then I would say that they could, yes.
Okay, right. Thank you, Leo.
Any other questions for legal? All right, we're back in session. Any other questions for the sponsor, Leader Lambert?
Just a quick question on the sponsor. So on this, I mean, just my read of it seems like you were trying to make sure that those recognized agencies out there that are dealing with animal cruelty and everything else are working with law enforcement. I think the bill that the representative from Knox County referenced earlier dealt with private individuals that were going in undercover into facilities and somehow restricting their ability to move forward. Your bill here, I don't think goes into that area. It appears that it just deals with recognized humane societies and animal control divisions of law enforcement. Is that accurate, Chairman?
Go ahead.
Yes, sir, that is correct. That's what the goal is to have that interaction between these organizations and law enforcement for many reasons, but mostly from one that I can think of as a safety issue. The last thing that you want to do is see strangers walking across your property, especially in this day and time, and they're taking animals from your backyard or from off of your farm, and you don't know why at that point. And so if at least if they're notifying law enforcement of what their intent is to enter that property, maybe they're even notifying law enforcement for the intent to enter that property to see if these animals are being abused or neglected. In that case, at least they have notified someone.
Go ahead.
Mr. Chairman, and thank you for the bill. I will tell you, it is, I know there's some lingering parts of the statute that have been out there for a long time, but I think we live in a world now where this really is a law enforcement role, and it should be law enforcement if they're going on somebody's property or something else. The days of humane societies being able to kind of go out and self-police and everything else, just not a good idea. So, I mean, it seems like this puts some guardrails on this and just makes it where it's a more professionalized process. So thank you.
Representative Towns?
Well, I agree with the chairman, leader, because if you see somebody in your backyard, I would hope that law enforcement would accommodate these guys, because you saw a group of people in your backyard today, you don't really know what their mentality, that's in their mind. You don't know what's going to happen. So what you would tend to do is try to protect yourself and your property, and that could lead to no good end. And so, but they're not required to have law enforcement with them under this bill, are they, sir?
No, sir, they're not. And for many reasons, I guess you could say, is why law enforcement wouldn't be required to be with them. But the statute allows currently for these groups or individuals to enter private property. And again, for a number of reasons, mostly for the safety of those, and that they have that notification to law enforcement before they enter that property.
Representative Towns?
Finally, sir, does it have to be in the light of day? Because there's a different feel in entering somebody's property at night and they see dusk, or daytime. Is there a time restriction on it? Just curious.
No, so there is no time restrictions. And, there are exigent circumstances where things occur, and not everything occurs during the daylight hours. And so it could be something that happens at night, and they may need to access property. If they can notify law enforcement prior to them going on there, that would be, I think, beneficial for everyone.
Thank you, Mr. Chairman.
Representative Russell or Chairman Russell?
Thank you, Mr. Chairman. I want to thank the sponsor for bringing this bill. It's sort of similar to what repo companies does whenever they go onto property to repossess a car. They're just notifying law enforcement of where they're going to be, what they're doing, so that there's no misunderstanding in the process. And also, by notifying the law enforcement officers, it gives them extra eyes on the animals in case of cruelty cases where they can check up on it later. So thank you.
All right, any other questions for the sponsor? All right, we're voting on House Bill 2691. All those in favor say aye. All opposed, no. The ayes have it. Moves to criminal full.
Okay.
Number 46, House Bill 2023 by Clemens. Rolled a week.
All right, members, that completes our special calendar. We're now on our regular calendar that we have for today. We'll go over a few things here. Item number 21, House Bill 2898 by Representative Kumar, rolled 1 week. Item 22, House Bill 1600 by Representative Williams, rolled 1 week. Item 46, House Bill 2023 by Representative Clemens, rolled 1 week. Representative Towns.
Mr. Chairman, I was just curious. How many bills on the regular calendar today?
86, sir.
Thank you, sir.
You're welcome. Item number 1, House Bill 1659 by Chairman Hicks.
Thank you, Chairman.
Recognized.
Committee. House Bill 1659 simply raises the base salary for district attorney generals and district public defenders.
Chairman Holsey.
Thank you for bringing the bill, and they deserve it. It's been quite a while. I thought if I said those nice kinds of things, they wouldn't be against some of my bills, and so I just went.
Representative Towns.
Certainly, we know they deserve it based upon what I've heard. Not nearly receiving enough compensation, but tell me what that takes us up to. Give me the numbers on each category at this point. Salary.
Representative Towns, right now, the base pay is $156,024, and it will be raised up to $205,328.
That's for each one, each
Yes.
category. That's a little bit more respectable, especially still, a lot of them are still paying off student loans. So it came through the committee a year or so ago that it's unbelievable just how little some of these guys were being paid. Okay, thank you, sir.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 1659 to full criminal. All those in favor say aye.
Aye.
All opposed? Ayes prevail. You move forward.
Thank you, committee. You're down to 86 now, bills.
Item number 2, House Bill 2505 by Representative Harris. You are recognized.
Thank you, Chairman. And if you could tell me which bill it is again, I have to read back to back.
2505.
Awesome. Thank you so much. And 2505 is the firearms and ammunition in regards to just maintaining ammunition in an area inaccessible to a customer in a retail establishment. When you go to Walmart, for example, you'll see ammunition sitting on the shelves, but there's like a glass, they're behind the glass. But if you go to a place like Academy Sports or somewhere else, you'll just see them sitting on the shelf where you can just freely just walk up and grab ammunition. And so there was a situation that took place where a child was walking around with ammunition in their hand inside of the store. And so this is just to put it behind a case of some sort. It can still sit out there on the shelf if needed. And it's kind of similar to like baby formula or some other items that you see inside stores, but just putting it behind some type of casing so that way it's not accessible on the shelf to a child.
Leader Lamberth.
Representative, you've brought some bills that I've supported before, but I'll be real straightforward. This one doesn't make a lot of sense to me. So even in your example, what is the harm? What are you concerns going to happen with the ammunition without it being loaded into a firearm? The ammunition is an inanimate object that is just ammunition.
Thank you, Chair. And so to that point, it's a small object that can be a choke hazard to a child. And so if a child can be able to grab it off of the shelf, like this example, it's something that we should look at.
And thank you. I was just wanted to kind of know the understanding there. I understand your example, but I will tell you in the stores that are in my area, there's some ammunition they put behind the counter. There's other that's out on the shelf where you can access it. Usually, at least in our community, especially around dove season or something else, I mean, your shotgun shells and that kind of stuff are going to be out that, folks can be able to access that more easily, be able to purchase it quicker, that kind of thing. It doesn't require calling a staff member down just for something like that. They're obviously checking age and everything when someone checks out. But it does put quite a bit of a burden on some of my small business owners. And I know you mentioned a couple of big box retailers. I personally feel like if you're buying ammunition at a big box store, you're probably making a mistake anyways, but I prefer to shop with small business owners whenever I can. And this really does make it extremely difficult for them, because when you go into a small store and if every bit of ammunition that they carry has got to be behind the counter somewhere, it's putting a real unfunded mandate on them. So I wanted to understand kind of what the purpose of the bill was. And I know you put a lot of thought and work into your bills. But this one's a bridge too far for me, mainly because of those small business owners that would have to completely refigure their entire stores. And it just doesn't seem like it makes a lot of sense to me, but thank you.
Thank you, sponsor. And so I'm glad you said that. I have put a lot of work into it. And so I have spoken to a lot of small business owners and large ones, and both had no issue with this, especially because I put a time that's further out for them to have the opportunity to put up some type of plexiglass or safety protection, so that way that we can make sure. One owner in Shelby County actually said that they actually would like this because they feel like we're all just trying to advocate for a little bit more safety. And this is just a safety mechanism while a child or anyone else is inside the store.
And just one other quick thing. Why do you want them to go to jail for 11 months and 29 days if they violate this? Because I was a little surprised to see that it's a Class A misdemeanor if they violate it, which is why it's in this committee. So let's just say somebody's stocking shelves in one of these small businesses you've spoken to, and I don't know if you share that particular aspect of the bill with them, and some kid inadvertently puts a box of ammunition, a shotgun shells or something like that on the wrong shelf, and it's not behind the counter, it's not behind there. All of a sudden, that kid should go to jail for a year just because they misshelved something?
Thank you, sponsor. And so with that being said, the standard, I guess the classification of the misdemeanor A is in place because it would technically be somewhat of a violation. And so I am not against any type of violation when it comes to someone either, well, stealing an item off of the shelf or placing something that could be in harm's way of a child.
Okay. Representative Johnson.
Thank you, Mr. Chairman. I guess the thing I thought of is we have such a epidemic of gun theft that when, somebody might steal a gun, but may not have ammunition. But if they are able to get access to ammunition and steal it because it's not behind a cabinet, that can ensure that there's a dangerous person that had stolen a gun, and now they have access to ammunition as well. So thank you.
Thank you, sponsor. And so I also agree with that too. That wasn't something that I thought of when I was doing this legislation. It was more so just around child safety. But we do have such a high level of gun theft to the point where it does make it a lot easier for people to want to access because they can just grab the bullets that are on the shelf for somebody. So thank you for stating that.
Representative Towns.
Go ahead.
All right.
Thank you.
Representative Fritz.
Thank you, Mr. Chairman. You mentioned several merchants that you spoke with. Is there anything that precludes them from putting it behind glass or something now?
Nothing precludes them from doing that. It's just a choice to do it or not. It's kind of like, again, like baby formula. You go into a lot of places, it's not required to put baby formula behind but it's something that's often stolen. So it's something that a lot of retailers find as a high theft item, as well as the ammunition that you'll see on the shelves as well.
Yeah, so if it's just a choice item, I would offer that nothing prevents them from doing it today. Why would we make it a crime to imprison someone for a period of time because they didn't do that? So I'll have to be a no in your legislation.
Thank you.
Any other questions for the sponsor? Oh, yes. Representative Russell.
Thank you, Mr. Chairman. I also share the same concern on the cost of the businesses. I think it should be a self-initiation for them to do just like the big retailers. And if they want to do it, they can. And that don't leave people not able to go out and lobby the businesses to do that themselves. And I just have an issue with putting jail time and a fine on a business if they don't do it. So, thank you.
Representative Hardaway.
Thank you, Chairman. And thank you to the sponsor for the bill and the thought that you put into it. I thought about a couple of things. We put magazines behind the counter that aren't appropriate for young folks in terms of what they should see and what they shouldn't see. You can't walk in and get certain paraphernalia off of the shelves. You have to ask for it, and it's behind the counter. So there are certain items that we look at now where we balance the cost of doing business, as it was referred to earlier, against the public interest. And I would say that this is definitely in the public interest to make sure that some of these stolen weapons that we have, the thousands every year that are disappearing from cars, they're not necessarily stealing ammunition when they steal the weapons. And in some way, shape, or form, they've got to go get ammo. And if they're stealing weapons, you can bet that they're going to steal the ammo. They're not going to turn over a new leaf and become honest citizens and go buy the ammo for a stolen weapon. So I think it makes a lot of sense to me. I think that when we weigh the cost of doing business, that it would put on a small business or on a big box retailer, that the cost of doing business it's minute compared to the public interest that will be served. I think it will literally save lives, and I think that it will save lives in more than one way, whether it's homicides, whether it's suicides, or whether it's accidental shootings. So I thank you for the bill. I would suggest that maybe it needs a little work so that you take the 1129 off and perhaps you have a fine only at some point. Maybe it's not at the initial infraction, but at some point that you have a fine as the penalty, the ultimate penalty for your legislation. Thank you, Mr. Chairman.
Yes, sir. Thank you. Representative Russell.
Question on the bill.
Well, I'm sorry. Second. All righty. Question's been called. Any objection? Seeing none, we're voting to send House Bill 2505 on the full criminal. All those in favor say aye. Aye. Those opposed?
No.
Noes prevail. The bill fails. Item number 3, House Bill 2509 by Representative Harris. You are recognized.
Thank you, Chairman. And so, let's see, 2509 as introduced adds that a person who is an accessory, let's see, no, it's not the correct one. Okay, 2509, a person. So this goes back to our victims compensation policy that we have right now. There is nothing that's currently in code that has the measures as to who is not eligible to receive the award. There was a situation where it took place where an individual in my community lost their child, and because of the way our law was interpreted, the other person who actually was part of committing the crime benefited actually from our victims compensation. And so this right here specifically says that a person is not eligible to receive an award with respect to a claim under this chapter if they are criminally responsible for the crime, an accomplice to the crime, an accessory after the fact of the crime, or have contributed to the crime. So that way that it's more clear when it comes to the application that they complete and fill out at a lot of these different organizations that help them get through this process of the Victims Compensation Award.
I do have a quick question for you. So currently, those that are criminally responsible for the crime or an accomplice or has contributed, they're not eligible to receive.
They're not, but by law, there's nowhere that quotes that in our code. It's only based off of the application. And so whoever creates the application is basically having to review that application, and that it's by interpretation right now. And we can go to legal and they can read the code if they.
Okay. We'll go out of session here from Legal Services.
Michelle Fogarty, Legal Services. Under 2913-105 subsection B, it states that a person who is criminally responsible for the crime upon which a claim is based, or an accomplice of such person, or anyone who has contributed to the crime in any respect, shall not be eligible to receive an award with respect to a claim under this chapter, which is the chapter on criminal injuries compensation.
Thank you. And so when I actually met with 2 attorneys from our legal department and went over this legislation. So for them to say it's in the code now is odd because we pulled it up together. I just wanted to make sure I stated that.
Any other questions for Legal Services while we're out of session? Representative Davis.
So yes, so for legal, what you just read is what is currently in code. Is that accurate, or is that?
Yes, ma'am, that's correct.
Leader Lamberth.
Well, I was a yes on the bill until the sponsor decided to get into it with legal, but I'm going to try to ask a clarifying question because I trust them explicitly on the advice
absolutely.
they give. So what would this particular bill add new into the statute that is not currently there?
Michelle Fogarty, Office of Legal Services. It specifically adds an accessory after the fact for the crime. Under current law, anyone who has contributed to the crime in any respect is already barred, but this would specify, add additional specification, if you will, that an accessory after the fact is someone who has contributed in any respect to the crime.
Thank you very much. And that's why you should never argue with those folks. They're trying to help you. So thank you.
Thank you, Chair.
Any other questions for legal? Seeing none, we'll go back into session. Questions for the sponsor? Representative Johnson.
I guess so. Accessory after the fact, I think about a recent situation that happened in Knoxville where it was somebody who had the perpetrator. So if they were somehow there, were injured, that would, I think that's a good add to the statute. So I appreciate that.
Leader Lamberth.
Move previous question.
Previous question called. Any objection? Seeing none, we're voting to send House Bill 2509 on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward.
Thank you, Chair.
Item number 4, House Bill 2513 by Representative Harris. You are recognized.
Thank you, Chair. And so with House Bill 2513, what this does is add a enhanced factor for a defendant who is wearing a mask at the time of a crime when a crime is commissioned. We have had a lot of situations back home, and I've been working with our local law enforcement on this as well, where individuals who commit a crime, we have to use additional resources in order to track them down and whatnot because they have on a mask of some sort when they commit the actual crime. So that's what this legislation does.
Representative Gillespie.
Thank you, Mr. Chair and sponsor. Thank you. I know this is something that both Chief Davis from the Memphis Police Department and our sheriff and other municipal law enforcement back home are all supporting. Quick question, just making sure I'm on the same page from those prior conversations. What this would simply do is, let's say an assailant goes in and robs a bank or a grocery store. Let's not use a bank. Let's use a grocery store, and they have a mask on while doing it. This is just adding an enhanced sentencing guideline to that already existing crime.
Sponsored. Thank you, Chair. And so that's absolutely correct. So they've already committed the actual crime. So the crime is what they are technically being reviewed for. But when sentencing takes place, they will get an enhancement for actually having on the mask because the mask is where they were trying to conceal their identity during the commission of a crime. So yes.
Oh, thanks. Thank you, Mr. Chairman. Yes. Okay, great. In the last, 10, 15 years, the state of Tennessee, the city of Memphis, and a lot of private organizations and citizens have invested in millions and millions of dollars in cameras, whether they're on street poles or in businesses. And the bad guys know that, so they put on masks while they commit the crimes. So I 100% support this, and thank you very much.
And Chair, we had a business that's in my district and part of your old district that called Buster's, which has had multiple incidents take place. And so this is something that could in the future help prevent some of the activity that takes place in that area.
Representative Fritz.
Thank you, Mr. Chairman. I appreciate what you're trying to do. I'm supportive of it. I just think that the last 3 or 4 years, we've found a place where if you go to a bank, if you go to the place where I do my banking, there's a no ball caps, no masks sign on the bank to go in. And lots of people don't abide by that today. So again, I'm fully supportive of what you're trying to do, but we've entered a cultural area where masks has become kind of an acceptable thing. And I just wonder if we've thought through this fully.
Yeah, absolutely. I think that people should still continue to wear their mask. It's wearing a mask during the commission of a crime, not wearing a mask because it's cold outside. It's not wearing a mask because of a health crisis that's going on. It's wearing a mask after you have went and robbed someone, wearing a mask because you've killed someone. We had a pastor who got killed in a driveway in Memphis. The person was wearing a mask. And so those things calls for time really does matter in a lot of crimes that are committed. And so for somebody to be trying to search for an individual who may have committed a crime and local law enforcement having to struggle to find that person because they had on a mask and trying to find different ways to identify a person based off of how they were dressed or who they were with during that time it takes a lot longer when the person has on a mask. And so this is just after they've committed the crime, and they are more than likely going to be convicted for that crime. Once that happens, then they will also be enhanced penalty factored added because of the mask.
Chairman Olsey.
Thank you. I just wanted you to know that about 2 years ago, I ran the same bill. And the front page of the Tennessean came out and said I called it a hoodie bill. And I got blasted with about 10,000 emails about how stupid I was running a hoodie bill. So I'm going to vote for your bill, but I'm going to name it with an amendment to Harrison Hoodie Bill. It's a great bill, and it's a shame it didn't pass 2 years ago.
Thank you.
Representative Johnson.
Thank you. I'm curious what the enhancement is. We keep talking enhancement, but I don't see it just in my short notes. So,
Yeah, the enhancement factor is something that the judge would determine at the time of the sentencing. Not, yeah.
Representative Davis.
Thank you, Mr. Chairman. And thank you to the sponsor. Chairman Halsey kind of stole my thunder. That was going to be my question would a hoodie also be considered, where you have under other device, would a hoodie also be something that could be included in that because it is trying to conceal your identity?
And no, I will tell you that that is not the case. Initially, the original language did say hooding or face covering. If I'm mistaken, I think that's how it was stated, but that part is not in there because it was too broad, and so it included things like a hoodie or a hat, and I didn't want to include that at this time because it's not the actual face recognition.
Okay, I like the hoodie bill.
Leader Lambert.
Thank you. I hope you succeed where the good chairman was unable to a couple of years ago. I would say that I actually think anything that would cover someone's face, I don't care if it's a hoodie or a facial scarf or something else. I think it's pretty ridiculous at this day and age, years after a pandemic, to still be wearing masks. But at the same time, if somebody's doing it, for health reasons, that's fine. If they're doing it to rob a store or something, look, that obviously there should be an enhancement there because they're trying to, conceal their identity. So, the language, it is very straightforward. The defendant was wearing a mask or other device that concealed the defendant's identity during the commission of the offense. So I think anything you're putting over your face and trying to conceal your identity, it is an enhancement. So I appreciate you bringing the bill. I hate that the good chairman couldn't get it passed a few years ago, but hopefully yours will get less media attention, so to speak, than the previous bill, because it just seems like common sense that if somebody's concealing who they are to commit a crime, then that's worse than somebody that at least is, easily identifiable. So thank you for carrying the bill.
Representative Russell.
Thank you, Mr. Chairman. I want to thank you for bringing this bill also. Anybody that knowingly tries to hide themselves behind a mask deserves an enhancements to their sentence, and I appreciate you bringing it. I'm going to be voting for it. Thank you.
Thank you. I do have a quick question for you. If someone's wearing a mask, like COVID mask or whatever that we called during that time, and they are wearing that during the time where they are in a domestic assault situation, would this enhancement include that since they were wearing a mask?
I think so. It was in the commission of a crime. So I would think that the judge or the courts would interpret it in that way, I would hope.
But it would not be applicable to speeding. If you were wearing a mask and driving up the interstate, it would not be an enhancement on the speeding.
From what I was under the impression of, it would not, no.
Okay. Any other questions for the sponsor? Yes, sir. Representative Fritz.
Thank you, Mr. Chairman. Just a quick question. I think that's a great thing to explore. I looked at 4035-114, but could we get a legal opinion on exactly what that means?
We can. We'll go out of service or session, excuse me, hear from legal services.
Michelle Fogarty, Legal Services. Can you repeat your question, please?
Yes, ma'am. Just what are the definitions under 4035-114? What all can be enhanced by this wearing of the mask? Is it specific?
No, so 4035-114 list about 31 different factors that the court can consider when they are sentencing a person who's been convicted of a crime. And they can use those factors to enhance the sentence within the range. For example, the range of a class A felony is not less than 15 years nor more than 25 years. So the court, if a person was convicted of a class A felony, the court would look at the 31 different factors, and if any one of them applied, the court could use that in their discretion to decide where in the range to enhance it from the low of 15 to the high of 25.
Any other questions for legal services? Representative Russell.
Thank you, Mr. Chairman. Just to clarify, this is just only enhancement for felony offenses within that statute.
It just says if appropriate for the offense and not already an essential element of the offense, the court shall consider, but is not bound to the following factors to determining whether or not to enhance the sentence.
Thank you.
Any other questions for legal services? If not, we're going to go back into session. Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2513 on the full criminal. All those in favor say aye.
Aye.
All those opposed? Ayes prevail. You move forward.
Thank you, Chair, and thank you, committee.
Item number 5, House Bill 2106 by Representative Dixie. You wish to take that one without objection off notice. Item number 6, House Bill 2107 by Representative Dixie.
Off notice as well.
Off notice. Item number 7, House Bill 2417 by Representative Dixie off.
No.
On notice. Okay.
Oh,
You are recognized.
all right. Thank you, Mr. Chairman. You almost got me there.
Yes, I had you say it off
We was
notice.
on a
I was gonna
roll. We
keep
was
it
on a
rolling.
roll.
There you go.
Well, this bill, it was a continuation from last time. We ran out of time. So this is basically to try to clear up the process and the procedure for restoring citizenship rights for a felony conviction between 1986 and 1996. Under the statute, the process for someone convicted between those years is to request form pardoning from the pardoning authority or the agent or officer incarcerating authority to be sent to the coordinator of elections. Unfortunately, there's no form to be sent. So it appears that only voting rights will be restored only if you were convicted before 1986 or after 1996. So this will help clarify and hopefully clean up what the issue is. Mr. Chairman, I did have someone that would like to speak on this. If we could kind of go ahead and let them talk.
We can. We'll go out of session. Hear from Keita Haynes. If you will, you can have a seat there, turn the microphone on, introduce yourself for the record and who you represent, and you will have 3 minutes for comments.
Good afternoon. My name is Keita Haynes, and I am the Senior Legal Counsel at Free Hearts here in Nashville. I'm also a former public defender. At Free Hearts, I have assisted and educated individuals as well as the community on the rights restoration process that is the subject of this bill. Additionally, I work with other lawyers through the Access to Justice Commission under the Tennessee Supreme Court to train lawyers and assist individuals with the rights restoration process. In Tennessee, when an individual is convicted of a felony, there are certain rights they lose, such as the right to serve on a jury, to possess a firearm, to vote, to hold office, and to serve as a fiduciary, to name a few. However, these rights may be restored through the procedure set out in TCA 4029-105. Unless and until these rights are restored, the citizenship disabilities will remain in effect throughout the individual's life. What procedure an individual must follow to have their citizenship rights restored under the statute depends on the date of conviction. Section A outlines the procedure for convictions before July 2nd, 1986. Section B for convictions between July 1st, 1986 through July 1st, 1996, and Section C for convictions after July 1st, 1996. The procedures in Section A and C are similar. Both sections refer to the courts as the mechanism for the petitions after a certain time period. They both state that evidence is needed, and they state the petitioner's burden of proof. They also have a notice requirement to the district attorney, and the petitioner is required to pay the filing fee. However, in Section B, a completely different procedure is outlined for individuals with convictions between July 1st, 1986 and July 1st, 1996. And this is the section that HB 2417 is amending. Unlike Sections A and C, Section B does not provide a detailed procedure involving the court system. It instead requires an individual to request and be issued from TDOC a certificate of restoration form created by the Elections Division. But where is this form? Lawyers, individuals with convictions during this time period, and even judges have asked that question. The unavailability of this form leaves individuals with convictions during this time period with questions as to how they may restore their citizenship rights. HB 2417 will answer this question. Not only will it provide uniformity with Sections A and C, but it will also provide a clear, concise, and effective method for how individuals who have convictions between 1986 and 1996 may apply to have their full rights of citizenships restored. And I ask that you support this bill. And if you have any questions, I'm prepared to answer them.
All right. Thank you very much, members. We have any questions for our guest, Representative Johnson?
Thank you. I know that I've tried to work with the folks in my county trying to get their rights restored, and it's really, you have to run a gauntlet. And so can you just speak to a little more specifically how this will streamline things?
So this will actually, the way that the bill is written, folks will be able to do exactly what people who have convictions after 1996 do, right? So that's a majority of what the people are doing. And so if you look in the statute in 105, 4029-105C, it actually is very detailed as to what people that have a conviction after 1996 have to do. And as I mentioned, it says that the petition has to be filed in circuit court. And it goes on to say that you have to present certified documents. It goes on to say that you actually have to have your burden of proof is that you actually have to show that, you know, you're a person of more character and that you deserve to have your rights restored. There is also a notice requirement to the district attorney. The district attorney, they can respond, they cannot respond. And then after that, the judge makes a decision, and the judge can grant you your full citizenship rights or the judge can deny them. You know, again, it's the discretion of the judge. And like I said, right now, if you look at the statute in Section B doesn't have any of that. Section B says that you have to go and you have to get this form from the Elections Division. As I mentioned in my testimony, this form is not available. Many people have tried to get it. And so folks within that time period are just left in limbo as to how they get their full citizenship rights restored. So this will just essentially conform with the rest of the statute and just make it, you know, easier for folks to, in that 10-year time period, to get their rights restored.
Okay, thank you. And I don't even think that's easier, but at least it does put everything on a single playing field.
Yes.
Thank you.
Representative Towns.
Thank you as well for the work you're doing. Question becomes, where's the form and why can't we get the form?
Well, that's the question that we all have. Like, where is the form? So, you know, people have asked the Tennessee Department of Corrections for this form. People have asked the Elections Division for this form. And everybody that have asked for this form has been told that this form doesn't exist.
Representative Towns.
Does the law say there's a form that is supposed to exist and so forth? Well, we need to be drilling down and figuring out why they don't have the form. You can't play this shell game. If it's in the books, it ought to be there. We should be able to secure the form. Now, let's say we did get the form. What would that do?
So if you did get the form, then the people within that 10-year time period would just be able to fill out that form in order to have their rights restored. Now, there are questions about, what rights that would restore, right? Because that's also a question. And so again, yes, we would like a form, but even with the form, there's still a lot of questions that surround that form as to what rights you will actually have restored with that form.
Mr. Chairman, I'm going to suggest, coupled with, the bill being passed, we figure out what the form is and we go to the right place to make sure they provide the form for the citizens of the state of Tennessee because it's in the books. So it has to be a form somewhere. If not, somebody's not telling us the truth. We need to get to the bottom of it. Even if we still do this, we still need to make sure that department provides that form. And as members, please.
Can I just say, because I'm a lawyer in a lawsuit with the elections division. And so we have deposed individuals from the election division who have said that this form does not exist.
Yes,
Well, Mr. Chairman, what I'll say with that is that if it does not exist, the question becomes, why is it in our books that says that it does exist? That means somebody's not telling the truth. And if it does not exist and we suppose to have a form, we should develop a form that makes it what the law says. Okay, so we just got to do some more research, and I'm saying to be continued because it's something that we're saying that ought to exist, and we need to figure out why. So I want to work with you and see if we can get to the bottom of it. I'd love to work with all three of you guys. Okay, thank you.
Representative Towns, I will say there is a form on the Secretary of State's website. It is titled voting, restoration of voting rights is what the form. There's an old AG's opinion that states that is the form that you would need, but there may be some confusion because of the way it's titled, but it is available on the Secretary of State's website. Representative Hardaway.
Thank you, Mr. Chairman.
Thank you, Chairman, and thank you for being here, ma'am. The goal is to place everyone on the same level playing field. Is that a good way to phrase it?
That is a good way to phrase it.
And right now, there's not a pathway that wouldn't go in circles or off the road in order for these individuals to get restoration of rights.
No, it would not. And it would alleviate any confusion as to what the form is, what form applies, because the form that is available right now on the website is not the form that was created for this particular statute here. And so again, so it would alleviate any confusion because it would just say that people would file a petition in circuit court is what it would do. So it would alleviate any confusion as to what this form is, who has it, which one is applicable at this time, all of those other questions.
And reducing that to a sentence, the form would be obsolete.
Exactly.
Okay. It makes a lot of sense to me. I think everyone ought to have the equal opportunity in this area to regain their rights. And I appreciate the sponsor for recognizing the problem and for being able to craft a bill that addresses it. Thank you.
And can I just say that the form that's online that they're referring to, that's for voting rights. If you look at the statute here, this doesn't say specifically voting rights. It says citizenship rights. So that includes more than just voting rights.
Thank you for that clarification.
Any
Thank
other
you, Chairman.
Yes, sir. Thank you. Any other questions while we're out of session? Yes, sir.
While we're out of session, I'd just like to ask legal, was that a true comment or the statement that she made that it does only apply to voting rights and not citizenship rights?
Michelle Fogarty, Legal Services. The certificate on the Secretary of State's website is titled Certificate of Restoration of Voting Rights. There is a 2002 AG opinion that addresses the title of the document and whether or not it may be mistitled or something.
Thank you.
All right. Any other questions? See, now we're going to go back into session. Thank you for being with us today.
Thank you.
Any questions for the sponsor? Seeing none, we are voting to send House Bill 2417 on the full criminal.
I don't want to hold up the process, but I just kind of wanted to just add in it. How this came to me was a grandmother. I think everyone's probably heard this story at this point, but a grandmother, she was the caregiver for her the intellectually disabled granddaughter. Her daughter turned 19, so she wants to become a fiduciary agent for her daughter, but she has a felony that she caught in 1989. But if she had did it in 1999 or 1984, it would be no problem. But this is a problem for her and so many others. So this will help tens of thousands of people by just putting everything back on a level playing field. And so I would appreciate you to give that consideration, and I hope that you will vote yes.
All right. Any other questions? Seeing none, we're voting to send House Bill 2417 on the full criminal. All those in favor say aye. Those opposed? No. Ayes prevail. You move forward.
Thank you, Mr. Chairman.
If you wish to be recorded as a no, please see the clerk. Item number 8, House Bill 2329 by Representative Pearson.
What do I got to say? You got to switch it up. There you go.
All right, you're recognized.
Thank you. Got 3 motions. First. Thank you so much. Mr. Chairman, members of the committee, before you is House Bill 2329, the Repeal Permitless Carry Act. This bill would just strike the line out of section 39-17, 1313A, which says, quote, or who lawfully carries a handgun pursuant to section 39-17-1307G. This bill, in effect, reinstates the permitting requirement to conceal and carry a handgun in public spaces, regulating possession, transportation, and storage. Gun violence is the #1 killer of children in the state of Tennessee. We have to treat it as the epidemic it is, and as legislators and people of good conscience, we must do everything that we possibly can to address this crisis. Look, when this bill was passed, a lot of people in District 86 in Memphis and Shelby County and across the state were opposed to it, including our chief of police. And I know how much we respect the opinion of law enforcement up here. The concern was that this would lead to an increase in violent crimes with guns. Another concern was that it would prevent law enforcement from being able to decipher between law-abiding citizens and those who only intend to do us harm. Concerns were raised that there would be an increase in homicides due to the violent offenses that would occur by people having access to weapons in our state. And each and every one of these concerns, unfortunately, has become a part of our reality in the state of Tennessee, most especially in Memphis and Shelby County. The actions taken by this General Assembly and legislature have had dire consequences for people whom we love and whom we care about. And so today I'm asking only that we right a wrong. I think about Larry Thorne. I think about Dr. Yvonne Nelson, Reverend Dr. Artur Easton Williams, who were all killed tragically in our city and were killed by folks who did not need a permit to carry their weapons. Just a couple of weeks ago, I mentioned Pastor Livingston, you all know, on the House floor. And his grandson said this. He was shot in the mouth. He is surviving his wounds. He's from Southwest Memphis. He said, his grandson said, honestly, I'm sick and tired of losing people to gun violence. I've lost 7 friends due to gun violence, and I'm nothing but 17. It's time to stop the violence. It's time to stop the robbing, stop the killing. It's time to put the guns down. When this body repealed a permit requirement to conceal and carry a handgun in most public spaces, since then, gun deaths in our state have risen. I've spoken to law enforcement officers. Again, our own police chief has pleaded for us not to pass this law. And surprising to all of you, I'm going to quote John Harris, who leads the Tennessee Firearms Association, who I never thought in my life I would agree with about anything. And he said, if you want to carry a gun for self-defense in Tennessee, go get the permit. Do not rely on this new law. Over 59% of Tennesseans do not approve of having access to a firearm without a permit. And in our city, where over 398 people were killed last year, overwhelming majority of them due to gun violence, it just shows that this uptick is a problem that does need a solution. The research goes on to say permitless carry laws make law enforcement's job harder and more dangerous. Honestly, in our city, and you all saw the news about this, an individual shot one of our police officers. God bless. They are recovering from their injuries as well during a traffic stop. We are not making it safe for our community. We're not even making it safe for our law enforcement officers. And so while I appreciate the intent of this legislation, right, you want folks to be able to have access to their firearms, reduce barriers as it relates to people's belief in the infallibility of the Second Amendment, we have to also recognize the increase of the amount of guns that are in our street and the increase of violence that we have seen. And so to allow for people to be able to carry concealed without a license, without any training, without any documentation, I mean, you don't even have to go to a class. I think it really is putting us in a dangerous position. I'll just tell you this last thing. I went to Top Gun Memphis, and Oceanay and I, and the instructor there, Mr. Lloyd, a great guy. The first thing he told us, he said, we need to make sure that people have a permit to carry a weapon. Now we're in a place where everybody is in at the range already, and he has more firearms than I have, anything. And his advice was that everyone in there, every instructor, everybody he talked to, everyone we spoke with would want to ensure that people would at least, if you were going to be a responsible gun owner, that you would have a permit. So you learn about safe storage, you learn about protecting kids so that they don't get access to these things. This is our responsibility when over 1,500 people a year are dying in our state. And so for these reasons, I do ask that you support a repeal of this legislation so that we are not the number one. Gun violence is not the number one killer of children in our state. We're 36% higher than the national average, over 60 children killed due to homicide each year. These are not things that we can take lightly. I'm open to amendments. I'm open to a real summers. I'm open to everything because I want us to do everything possible to change the direction that we are currently going. And so with that explanation, Mr. Chairman, I renew my motion and stand ready for any questions you might have.
Boy, you hit that 5 minutes right on the mark.
I practice.
You have. Chairman Halsey.
Thank you, Mr. Chairman. So I'm just making sure that your bill is a complete repeal of the constitutional carry we passed a couple of years ago.
Yes, sir. And Mr. Chairman, the reality is, and I know this is near and dear to a lot of people's heart, but I think when you look at the ramifications of legislation, you have to say, what is it that we can do to fix the problem? And the reality is this likely went too far in one direction. And it has led to really unfortunate consequences in our community in Shelby County and Memphis, but across our state. And I think if we are to do this, there have to be some more incremental steps that could have been taken or should be taken moving forward. But we do not need to make it so that anybody can go, and you can go and purchase a weapon today, whether that be a handgun, an assault weapon, or any of those types of things without even having to have a permit. And if it's not a permit, right, if you don't want to reinstitute permit, at minimum, take a course or a class. Again, I'm not doing any advertisements for Top Gun Memphis, but like go take a class, right, and learn about how to actually operate a firearm safely so that we can potentially reduce some of the deaths in our communities. Literally, we had on the House floor, and I believe this passed, to require children to take a class learning about firearms, but we don't require a class for parents or for adults, right? It's just, we know that there's a need for more education, and this prevents people from even having to take a class or get any more information about actually how to safely store, how to safely carry the weapon or firearm that they have.
I agree with you on the class part. I think it's a great thing, a great idea. Folks get trained. What's your answer when the Second Amendment says shall not be infringed, and you're saying that before you can exercise the Second Amendment right, that's very, very fundamental. You have to have a class before you can exercise that, particularly in light of the Bruin ruling out of the Supreme Court recently.
Yeah, I mean, the idea of the Second Amendment at the time that, right, it was written, and depending on if you're originalist or someone who turns it or does other things with it, it really had to do with the building up of a militia in the state. But our Constitution also, right, written after the Second Amendment, says that you can regulate and you should regulate firearms for the public safety. That's in our Tennessee state constitution, because I think the framers and the founders of this institution, just like the ones as complicated as they were who founded this country, did not assume that people would be able to get access to weapons to do such harm to our communities and in our communities. I don't think they were saying, let's have a Second Amendment so that gun violence becomes the #1 killer of children in our country. I don't think that was their intended consequence. Definitely an unintended one that has happened. And while I don't want to infringe upon anybody's rights, anyone's Second Amendment, anyone's constitutional amendments, I think what we also recognize is that our responsibility is to the people who elect us. Our responsibility is to the children who cannot vote, but who we are responsible for, who right now are dying overwhelmingly due to gun violence. And so it's not to take away anyone's access to getting firearms, and repealing permitless carry wouldn't take it away, right? This was the law for a long time. It's not taking away anybody's firearms. It's saying that if you're going to be in Tennessee, if you're going to have a firearm, at minimum, we're going to know that you know exactly how to use it, how to be safe with it. And in doing so, we're going to help prevent some really unfortunate loss of lives in our communities. Thank you for that, Chairman.
All right. Thank you all. Hate to cut the party short, but we are out of time. Members, we will meet immediately following criminal full this evening. We'll pick up right here where we're leaving off on item number 8. We'll pick back up immediately following criminal full. Criminal full meets at 4:30, and we'll meet right after that. House Hearing Room 3 for all those that are watching at home. Feel free to join us.
Thank you, Chairman.
I need a motion to recess until that time. All right, we will recess till immediately following criminal full.